402. And it's been marked as exhibit number 62. It's the Texas Occupation Code section 1701.269 of the Texas Burning Statutes, Texas Occupation Code. We assert that this provision is relevant to this proceedings, and we would ask the court to take judicial notice of it.
Noted that it is part of state law's occupation code, I would object on relevance matters. The code itself specifically addresses training of policies, the chokeholds, similar necrosis of police officers. It also addresses policies regarding the duty of a police officer to intervene or stop or prevent another for using excessive force. That would then be asking this officer to testify as to activity that he is not aware of and has not seen. He has not been designated by an expert. So I would object in terms of relevance with this officer.
Your Honor, counsel's argument is misplaced. 1701.269B 2A and 2B and 2B1 goes to the heart of what's at issue in this case, whether or not force was unreasonable, and whether or not it violates state law, which Chapter 9 of the Texas Penal Code, and the indictment is an issue in federal law, and it goes to the issue of excessive or unnecessary force. Now, counsel's argument is further misplaced because what this says is that police officers are given training and are told that they have a duty to intervene if they see the kind of conduct that's at the heart of this indictment. So what we want to be able to assert is that at no point in time did this witness report or hear anyone report what was required by the statute. He did not see or hear anyone report what's required by his statute in accordance with his training, then it becomes relevant. The fact that something didn't happen is relevant to the issue of whether or not the underlying conduct happened. So it is relevant, it is probative. In weighing, it's relevant under 401, 402, and under 403 analysis. Any potential prejudice is outweighed by the relevance. And to deny introduction of this statute and to deny introduction of the evidence we hope to elicit would deny us of a defense.
Brief response, Your Honor. Yeah, and again, this witness already testified from where he was, his vantage point. He did not see what the defendant's actions were down at that window. He could not inform an opinion. Again, defense has not noticed this officer as an expert. State has not noticed him as an expert. So he now attempts to bring in through the back door what his own experts designated would testify to. It would be improper bolstering. He doesn't have first-hand knowledge. It's inappropriate with this witness.
And again, Your Honor, it's counsel fails to understand the import of Barnes v. Felix and Graham v. Connor, and that is the totality of circumstances includes everything preceding the moment of truth. What we want to do is show that during the time that the threat became apparent was far earlier than when the defendants engaged in the conduct that's alleged in the indictment. It started 15, 20 minutes beforehand, and this witness had firsthand knowledge of what was preceding that moment at 2:02:07, and that's part of the totality of circumstances. And if anybody thought that there was provocation of illegality, then he was required to do that. The state has advanced some crazy theory that the officers committed some kind of burglary or trespass, and we're entitled to rebut that with this witness.
Judge, if I may respond, Mr. Harris, just briefly, with this witness, he did spend a lot of time talking about his 32 years of experience, and all the years of police experience and everything else. And I think what Mr. Cifuentes has done is asking the court to take judicial notice, and if they have any objections to the way that statute is being used with this witness, they can voir dire the witness on it. If it goes outside the expertise that he established that this witness had on his direct examination. And so we're asking first for judicial notice of the statute, and then any questions that they believe go outside his expertise, I think they can object at that time.
All right, so this is a law, this Texas Occupations Code. If I do a 404, not necessarily something that is relevant. I mean, you can examine, the court doesn't necessarily have to take judicial notice of the law. It's the law, right? And the court is providing the law to the jury. If you want to examine this witness regarding what is reasonable or not reasonable, or what it is he observed, or whatever it is he's a witness to, you can do that. The state is welcome to object. But in terms of this being the law, it's the law. And so that's just where we're at with that. You can cross this witness, and then the state can object if they feel like it. If there's a 403 or a 404 analysis that needs to come into play.
Correct. Approach the witness.
Yes.
I'm handing you what's been marked as Defendant's Exhibit number 61, and I represent to you that it's Section 200 of the Rules and Regulations of the San Antonio Police Department General Manual. Could you do me a favor and look through that and see that it's a true and correct copy of the General Manual?
It looks like it. As far as I can tell, it is.
All right, and so I want you to look at page 14 of that document. And does the San Antonio Police Department have a Rule 4.09, duty to report crimes?
It does.
And are you familiar with that rule?
Yes.
And what does that rule require you as a police officer to do if you observe any crime?
I am supposed to report it.
All right, and do you report it immediately, or do you wait until you figure, somebody's going to ask for my report, I better report it 24 hours later?
It's supposed to be reported on as quickly as possible.
All right.
Is what?
As quickly as possible.
And 4.10, can you tell the jury what that rule is entitled?
It's duty to report incidents.
And 4.10E, what is that rule entitled?
Incidents where the city may be liable.
All right, and what are you required to do if there's an incident where the city may be liable civilly for conduct by the police officers?
Objection, relevance as to this proceeding, and may we approach our
I'll sustain.
Your Honor, I would proffer that we're not offering it for purposes of what we've filed our initial motions. There's another purpose for which we're offering it, just to show an absence of a report.
We can ask him that.
All right. Now, Officer Chernak, regarding Rule 4.10E, did you, in connection with the June 23rd, 2023 incident, report that the city might be liable for conduct that you observed on June 23rd, 2023 at 6200 Old Pearsall Road?
Objection, Your Honor. I would like to take this witness on voir dire.
Okay.
Officer Training, in this incident, were you the reporting officer assigned to this incident?
No, sir.
That was Officer Vince Gomez that had the reporting responsibility, correct?
Wasn't, I'm still not sure who had the report responsibilities. I know it wasn't me.
Okay, in fact, you gave a witness statement instead of writing a report, correct?
I had to do a supplement to it. Even though I gave a written statement, I still had to provide a supplement report to it.
All right. And again, as you believe you testified on direct, did you observe the activity of the defendants at that bedroom window from your perch at the second bedroom window?
I mean, what they were doing at the porch?
Yes, sir.
I testified I couldn't see what they were doing.
Thank you, Your Honor. Your Honor, this witness by his testimony did not have the report writing authority for this incident. If you were to supplemental from his vantage point, it is improper to inquire for him the totality of the report of the incident. That was a separate officer. He's the wrong witness for this line of questioning.
Your Honor, that argument is very specious and illogical for the very reason that nothing in 410,
All right, it's also saying the sidebar.
nothing in 410 says that the officer is relieved of responsibility to report if some other officer has report writing responsibility. So he's required to submit a report irrespective of whether someone has report writing responsibility, and he testified he didn't know who had report writing responsibility. So if he didn't know who had report writing responsibility, he's not relieved from reporting.
All right, so again, ask him questions about whatever potential evidence is, and let's see how he responds.
Did you write a report pursuant to 4.10 that complied with 4.10E?
I completed, like I said, a supplement report.
All right, but did you report in that supplemental report that you believe that the city might have liability for what you observed?
Again, objection, Your Honor. Counsel is also further attempting to breach the court's pretrial rulings, and his next tactic will be to ask the state if we're going to give him immunity. It's improper line of questioning with this witness.
I would object to the sidebar.
Can we approach on that?
Sure.
Yeah.
One moment. Oh, that's it. Yeah.
way he said that was that we were gonna ask to give him immunity. The problem with that is that he is trying to make the jury believe that we think that they did something wrong and that they need immunity for it. And that their theory is falling off a cliff. Everybody realizes it, they realize it, and now they're trying to impute to us as if we believe that he would need immunity.
All right, so I'm gonna listen, on that particular defense objection, I'll grant that as it relates to the state making any reference to immunity. I'm reading exactly what the state said. It wasn't anything that was harmful in the court's opinion. So as a result of that, I'll grant it. I'll just remind the state, let's not talk about immunity in front of this jury, number one. Number two, as it relates to the state's objection regarding the line of questioning, what I asked up here, Mr. Cifuentes, is what specifically you're trying to elicit from this witness to that question?
It's real simple. They're trying to assert the officers have no right to enter the premise and they engaged in misconduct, and therefore they committed crimes and violated people's rights.
So I did sustain defense objections to that, right, on Friday?
Correct. But they even though it's been sustained, we want to be able to establish, just because an objection hasn't been sustained doesn't mean that there's an absence of evidence that this witness had the duty to report criminal conduct, had the duty to report civil misconduct, and he failed to do so. That goes to establish that there was no criminal misconduct and no civil misconduct, because what they're going to argue is that in the 2 seconds before the shooting, that in itself defines criminal conduct. And we know that's not true, that the totality of circumstances, the repeated threats, is what makes the belief that someone's dangerous and violent, and the threat of imminent force is necessary. If someone repeatedly attacks someone with a deadly weapon, that when they attack on the third time, or fourth time, or fifth time, that shows an intent to use the weapon. It shows an intent because we believe we're going to elicit testimony that she missed by inches when she attacked Villalobos at 151.50 with the hammer. We believe that Maria Salinas and Vince Gomez are going to establish that they missed and that Maria drew down, that she believed that Villalobos' life was in danger, and so that was conveyed to Eleazar. And so if it was conveyed to Eleazar, he had a belief, a reasonable belief, that Melissa Perez, when he saw at 2:02:07 her swing the hammer, that she had the intent to kill or cause serious bodily injury. And so if this witness didn't report any misconduct leading up to that, it's relevant.
Judge, one of their many odd theories is that Melissa Perez had the right to use deadly force against officers, inferring that the officers were doing something wrong or illegal, which they've given selective immunity to certain officers because they don't want us to have a defense. We'll bring that up at some later time. And so what Mr. Cifuentes is trying to say, Judge, that if there's a responsibility of every officer out there to at least report, if all these officers are doing something wrong and nobody reported it, then we can make the argument they weren't doing anything wrong. We all know they weren't, Judge. So that's all he's trying. I'm just trying to keep it really simple. Forget about civil lawsuits. We know they got poured out in a civil lawsuit in federal court. We get all that. That'll come up with experts. I'm talking about what Mr. Cifuentes is trying to listen from this witness is that there's a duty for every single officer in Bexar County, in San Antonio Police Department, to report on their own. They don't have to be the lead officer. Just they have a duty to report bad behavior or illegal behavior, and nobody did. That's all he's trying to get at this, Judge. And it goes to one of the heart of their theories that we all know is insane, but still, they're trying to present that. So we have a right to rebut it, Judge, and that's all that Mr. Cifuentes is trying to do. It's really simple, and I know it hurts their theory, but we have a right to a defense.
And another point.
Hold on. Yes.
Your Honor, I believe they need to tread this ground very carefully because they had asked for and were given the opportunity to have this officer's request for immunity hidden from the jury, and we agree with that, and that's okay. But if they're going to continue to go this route and say that there are things that he did that were unlawful, or that his other officers who were granted immunity
not saying that.
May I?
But we're not saying that.
May I? If they're
We're
gonna
not saying
continue to
that.
go in this thing and say that they failed to follow policy and that there were actually concerns about immunity, I believe they're going to open the door for us to be able to get into the fact that he was unwilling to testify without immunity.
Mr. Moonen is arguing to himself, 'cause we're not making that point.
All right, so-
No one said
I'm
that.
saying he's stepping into that, and
No, he's not.
I want the court to be aware that when that happens, that we should be able to respond to the fact that he was concerned enough for what his actions were, that he asked for immunity.
That makes,
It's not
that
true.
doesn't make any
He
sense.
did, because I gave him the option, if you remember, the option, and with his lawyer present, he could choose to either not take any immunity and continue to testify, or insist on the immunity.
He's
And I
concerned
said I would
about-
offer him the immunity if he insisted on it.
He's
That's
concerned
what I
about a
did.
runaway
I'm
DA's
sorry,
office
it's
that's trying to
hard.
charge all these officers.
Okay, let's get back to the heart of the matter. So, what does the duty for this officer have to submit a report or not? How is that an issue that is in front of this?
Your Honor, it's an issue because I guess it was around 4 o'clock that I read an email from Mr. Harris of a late disclosure of Chuck Joyner having changed his opinion about whether or not they illegally attempted to arrest her. And Mr. Joyner changed his opinion. I asked for a supplemental report to clarify. We haven't been given a supplemental report to clarify. All we've gotten is an alleged disclosure notice of their summary of events, which we have found repeatedly to be untrue or incomplete. And so it's important that since their expert has changed course, as their theory has changed course, we don't know whether they're even going to call Mr. Joyner. They haven't replied to my request. Are you going to call Mr. Joyner or not?
Your Honor, can I just, an analogy, I don't know if it might help the court, but in a business record, if there's a duty for information to be included in a business record and it is not there when it should have been, if in fact those acts had occurred, then that in itself is admissible. So in essence, that's what we're saying. They're accusing all of these officers of criminal conduct. So if that information is not in documents that would have been required to be produced under either the San Antonio Police Officer General Manual or the occupation code provision that Mr. Cifuentes cited, then that becomes relevant and admissible, if that helps the court at all.
And we also intend to introduce videos, and after we introduce the videos, or actually play videos for this witness, and ask after this point in time, did anyone come to you to talk about improper or illegal conduct? Since he's the senior officer on the shift, and you would think, and it stands to reason, that if someone saw something illegal, that they might come to him.
Okay, so let's get to this. Why don't you ask this police officer now the questions that you want to ask? The jury's not here, and let's figure out whether or not it passes 404.
All right.
Turn your microphone around, it's right behind you, there you go.
Officer Charnacki, being aware of Rule 4.09, did you ever write a report that complied with 4.09 of reporting criminal activity that you observed on your call at 6200 Old Pearsall Road on June 23rd, 2023?
Okay, are you talking about other officers, or are you talking about in general
Did you?
that I observed?
Yeah.
But overall, or any of the officers?
Did you write a report saying that you believe that the officers engaged in criminal conduct?
No, my supplement just was what happened, what my part of it was.
And nothing in the supplement said, I believe these officers committed crime, correct?
No, sir, I did not write that.
And would you also agree that you did not write a report that night pursuant to Rule 4.10E that said that you thought that the officers engaged in conduct that might cause civil liability to the city?
No, I did not.
And you saw certain videos before you testified today that Mariah Medina showed you. Would you agree?
She showed me some videos, yes.
All right, and you recall that after the point in time, thinking back to June 23rd, 2023, when those events on video happened, timestamp, you agree with me that no one came to you after that point in time that was marked on the videos to tell you that they observed conduct that might be criminal, correct?
Nobody is gonna come up to me and tell me.
All right. And no one came up afterwards telling you that officers had engaged in conduct that might result in civil liability to the city, correct?
Nobody approached me on that, no.
That's the testimony we're seeking to. And you didn't tell anyone that you believed that the plan Alfred Flores came up with was illegal, would you agree?
Whether the plan is legal or not, okay, you know, the plan that we came up with or what got changed, again, I can't say it was illegal or not because it got changed because of what they saw at the time, and I did not see it. So in a way, you're asking me to Monday morning quarterback something I didn't see.
Sure. So let me rephrase, and I know we're all tired.
You know, and I don't have firsthand knowledge of it.
Right. So let me ask it in a way that it's clear that I'm only asking for your firsthand knowledge as you knew the plan that existed at the time you heard it. So at the time you heard Alfred Flores give you a plan or directive, would you agree that what you heard at that point in time, nothing was illegal about it, correct?
I did not believe there was anything illegal about it.
Okay, thank you.
Anything related to?
In your 20s, just as that, your 20 years with SAPE, have you ever had the opportunity to pursue, as Mr. Cifuentes asked, Rule 410E, writing reports of incidents that could expose the city of San Antonio to liability?
I understand we're in a hearing outside the presence of the jury, but it's not relevant.
The council is zeroing in on this incident. I want to inquire about the applicability overall.
How overall?
Go ahead.
Every time we write a report on something, there's always that possibility, you know, that the city's going to be liable for something. You know, when we're doing stuff, especially, but as far as that goes, I have never had to write one where I've seen something that was so egregious that it was going to put the city in a bad place.
Okay, and so that answer would specifically per the code he cites, 14E, you've never, in your 20 years with SAPE, looked at and seen that opportunity?
I've never had to, no.
Okay, and it's normally your routine report as a patrol officer has always been sufficient.
Yes, sir.
And likewise, have you ever had the opportunity to write a specific report under 409 about writing a report of criminal activity? Anyone, you fellow officers, is that something that has come up frequently in your 20 years experience with SAPE?
With that, I have had to write reports that involve police officers and off-duty activities.
Yes, sir.
I've had to arrest officers for off-duty activities,
Yes, sir.
but I've never had to write one for an on-duty incident.
So, and again, anything that you observe is normally covered in your routine report.
Yes, sir.
And were you in a position to see what had happened down at the porch window when the events took place? Yes or no?
That's been asked and answered.
So clarity in this context, Judge.
All right, overruled.
Okay. As I've testified what happened up there at the porch after I'd moved over to the corner bedroom. I couldn't see anything as far as what was going on the porch. So whatever changed up there that was happening, I would be, if I were to say, oh, this happened, I couldn't, I'd be lying because I couldn't see it.
And would that same answer apply to any activity that occurred before you arrived at about when the E-tone from Officer Salinas went out? Could you have done, would you have the information to write either of those reports about that activity?
I wasn't present for that, so no, sir.
That's all I have.
All right, I'm going to conduct a 403 and a 404 analysis. I won't let either side get into interviewing or examining this witness related to any civil liability exposure or the occupations code. All the other questions are okay. Anything else?
Your Honor, I understand you're not gonna allow questions about the occupation code, but I believe we should be allowed to. Did you see anything that required you to intervene to stop any of the plans that were in place?
Yes, you can ask him that.
All right.
All right, there you go.
Judge, we would like an instruction to disregard on my sustained objection as far as any immunity. That was the last.
I'm
thing.
sorry, I didn't catch that.
Well,
Yeah, the last question by the,
yes, we would like an instruction to disregard on anything about immunity, which was the last thing the jury heard before they left the courtroom.
okay.
All right for the jury? You may be seated.
All right, welcome back, members of the jury. I'm going to instruct you to disregard the last question made by the state.
And Judge, just to preserve our error, we ask for this.
Overruled or denied.
Thank you.
Yes. All right, next question.
All right. How you doing, officer?
We're making it.
All right. So, if I ask a question that is confusing, please let me know. I want to make sure that my sole intention is to ask you questions based upon your personal knowledge that you understand that, correct?
Yes, sir.
All right. So, if I understand where we left off, we were talking about the San Antonio General Manual Rules and Regulations 4.09, and we said there's a requirement to report crimes, correct?
Yes, sir.
All right, and would you agree with me that there was nothing that you observed on the part of SAPD officers on the night of June 23rd, 2023,
No, sir, I did not observe anything.
All right, and had you observed something that was criminal, you would have written a report, naming the criminal offense, correct?
Yes, sir.
All right. Now, in your career, you have arrested San Antonio police officers off duty, correct?
I've had one or two, yes, sir.
But you've never had the opportunity to observe an officer commit a criminal act on duty, correct?
No, sir, I have not.
All right. And would you agree that you have had training in the San Antonio Police Academy where you're taught that if you observe conduct that's criminal or inappropriate, you have a duty to intervene and stop the criminal behavior?
Yes, sir.
All right. And could you tell the jury whether you saw anything on June 23rd, 2023 at 6200 Old Pearsall Road that would have triggered the duty that you have as a police officer to intervene and stop the activity of another officer?
I did not have any
All
that I
right.
observed.
And would you agree that you fully were aware of the plan that Sergeant Alfred Flores gave to you about arresting Melissa Perez on the night of June 23rd, 2023 at 6200 Old Pearsall Road?
Okay, I'm sorry.
Okay, were you aware of his plan to arrest Melissa Perez?
Yes.
All right. And as you heard his plan, and I realize the plan changed, but as you heard his plan up to that point in time, did you hear anything that you believe to be illegal or improper?
No, sir.
All right. And at my request, did you listen to some videos on headphones prior to you testifying today?
I did.
And were you asked to determine whether the audio matched the transcription that was imposed on the videos?
Yes, sir.
And what was your conclusion?
The transcription matched the audio.
All right. We would ask permission to play a clip of Vince Gomez. Body worn camera, and I believe that's going to be exhibit.
That would be states 10.
Sorry, Judge, we're testing on the break, we'll get it on here.
Okay.
Permission to publish, Your Honor?
Yes.
That was it right there. Oh, you're about to take another vacation.
That's not true at all. So I'm asking you to come out and talk with us peacefully, okay?
I don't need to talk to someone who's tearing my door down and molesting me and
Well, I didn't tear your door down. I
I'm
just
shining the light in his face along with mine and then turning my screen off. That's harassment.
Okay, so would you
Bye,
like,
please.
so would you like to come out and talk to us?
No,
Okay. So you're gonna make us go in?
you don't gotta want to.
I don't need one. I've already explained that to you.
I'm explaining to you, you need a work.
Okay. Well, we'll see what the judge has to say about it,
Okay?
okay? And then we'll figure it out at that point, okay? Okay. Well, like I said, one way or another, what's gonna happen is gonna happen, okay? I'm trying to explain the law to you so that this doesn't go, so that this doesn't happen again.
See how this went over?
What's gonna happen?
Alright, and is that video one of the videos you saw?
It was.
Alright, and you said the transcription was accurate, correct?
Yes, sir.
Alright. And, there was another video that you viewed, I'm gonna play that. And this is Eleazar's body camera.
Okay. It doesn't negate the fact, it doesn't negate the fact. Okay. I heard what you had to say. So if you're being harassed by your wife, this is what
No. And fucking Salinas was the first one that we shoot you down on. I saw her grab. No, you.
Okay, so, what we see is a person in the middle of the video, is that Maria Salinas?
I believe so.
Alright, and I'm gonna tell you that in probably a few seconds, we're gonna see Maria Salinas make a gesture. And after she makes that gesture, I'm gonna ask you a question.
That's right, you think that's respect? There's no words to tear my door down. Words is my window.
Okay, so I think it was at 157:38, I'm gonna stand up. Would you agree for the record that Maria Salinas, when they were talking about how close, she made a gesture, I think it was with her left hand, let me use the correct hand. She made a gesture like this with her thumb about an inch away from her index finger. Would you agree with me?
Yeah, she made that gesture.
Alright. And when police officers speak with other officers, you would agree with me, it's important that they obey Rule 3.02, which is to tell the truth at all times.
Yes.
And it's important because if you tell another officer that someone merely killed an officer or injured them with a hammer, that's vital information that they must know, correct?
I would say that's information that should be passed.
All right, and you're required to support fellow officers in time of danger, correct?
Yes, sir.
And by providing information that someone nearly struck someone by this much, a thumb and index finger an inch apart, that's vital information that should be conveyed, correct?
Yes, sir.
And since this is Eleazar's body camera, you would agree that he be entitled to rely upon the information that Maria Salinas conveyed at this point in time, correct?
Are you asking me if that he is able to believe what she's telling him?
Yes.
I would assume he should be able to.
All right, thank you. I'm gonna continue to play this. Okay, so you agree that Eleazar was told in this video that when Melissa Perez came sprinting at Villalobos, that she got very close with the hammer, correct?
I wasn't there at that point, but if
That's
that's what's being said on the video.
Okay, I got you. And I'm just asking you that you listen to that's what you heard, right?
Yes, sir.
Okay, what section of the law is that?
Okay, and I think I stopped at 157.59. You agree that one of the officers said they were scared for Villalobos, correct?
I believe there was something in there that said something about him.
Okay,
That
all right, so there's reference to taking another vacation. Would you agree that sometimes cops engage in dark humor to cope with the stress of ugly situations?
That would be an understatement sometimes. Yes, we have a very dark sense of humor to deal with
you
it.
yourself, no criticism of you. I know you're a senior officer, you've seen a lot of things over the years, some ugly things. But you would agree with me that you've been able to maintain your sanity by using dark humor in bad situations, correct?
It's a trait that sometimes we have to use just to keep from screaming.
All right, and so when someone's talking about a situation where they may have to shoot someone, and they make reference to taking a vacation, you would agree that that's not a statement that they consider someone's life worthless, or that they think it's going to be an opportunity to enjoy time in Hawaii or something like that. You would agree that's not what they're saying, right?
My experience throughout my entire career is we don't want to have to take somebody's life. It's a possibility of every day when I walk out my door that I have to come to the realization that it could happen today or it might not. It's something that I don't think any police officer that I know of would joke about in a manner that would be I know if they were referring to it, you know, in a high stress situation where we're using, you know, that dark humor that we have, to someone outside of law enforcement, they would probably think we're pretty, you know, kind of rude about it, you know, where they see it as, you know, an insult, but it's not. It's just us dealing with the task at hand and what's going on.
All right. Oops. All right, so let's see. I'm gonna play a video where it's a compilation sequentially of Vince Gomez, Neary and Lamb. Alright, and we saw a stretch of video at 1:59, I estimated it was like 1:59:15 through 1:59:28. And Vince Gomez illustrates to Neary and Lamb and others that Melissa Perez came this close to striking Villalobos in
Mhm.
the head. And when he gestured, would you agree with me for the record, that he put his palms in front of his face, facing each other at a distance probably 5 to 7 inches apart?
Yeah, the video showed he did that.
Alright, and he shook his hands for emphasis, correct?
Yes.
Alright, and you agree with me that all the officers who heard or saw that were entitled to rely upon that as a statement of fact that Melissa Perez came within 5 to 7 inches, according to Vince Gomez, of striking Villalobos in the head with a hammer.
I can't say what other people thought.
But they were entitled to rely upon that representation, correct?
Yes.
We passed the witness.
Mr. Sequenas, you need to set up a computer on this.
Okay, I'm sorry, let me move.
Thank you. Procedure on it?
Yes.
Bit of musical chairs here. Officer Chernak, before I shift gears here, it wasn't entirely clear to me, the vacation discussion, that wasn't any of these gentlemen here that were engaged in that, right?
To be honest with you, I couldn't tell you who all was engaged in that conversation. I don't believe it was, but
Right, it sounded like it was maybe Vince Gomez and Maria Salinas bantering back and forth a little bit, right?
it's hard to tell sometimes.
Sure, fair enough, and the videos will make that clear, right? I wanna pick up where Mr. Cifuentes, left off in terms of you describing to the jury dealing with difficult situations out in the field in your decades now of police.
Mhm.
It can be easy to forget that we're here talking about the tragic loss of human life, right?
Yes, sir.
And so none of us, and certainly Mr. Flores and Villalobos and Alejandro, none of us are diminishing the value of Melissa Perez's life. And I think that's a sentiment that's shared by all of SCP, right?
Like I said, I've worked 3 different departments. I don't know anybody who says, you know, I'm going to go out and kill someone today. We don't do that. That's not what we do. That's not how we're trained.
I'd like to show you Defense Exhibit 63. you and I discussed this earlier, but is this a photograph that depicts at least the same person that you all encountered that night?
I believe that's Miss Perez, yes. The one I've seen that I saw on the news after it happened.
Sure. This time, defense would offer defendant's exhibit 63, tender to the state for inspection.
No objection to defense 63.
Submitted?
May I publish, Your Honor?
Yes.
So that's Melissa, the photo of Melissa Perez, right?
Yes, sir.
But that's not the Melissa that SAPD got on that particular night, right?
No, sir.
On that particular night, this is not me being insensitive, but this is the Melissa Perez we got that night, as everyone saw her, right? This is defendant's exhibit 12.
When I got there, she didn't have the headband on.
Okay, fair
So,
enough. I appreciate you
but
clarifying.
that looks very similar.
And I'm not making a comment on having a headband or not. So defendant's exhibit 49 here. You see someone swinging a hammer through a window. That's the Melissa Perez that officers encountered that night, right? You'd agree?
If that's what's on the body cam.
Sure. And I would represent to you that these have been admitted as being stills from body cam video. And then states 52, we've got Ms. Perez there. Testimony is shown with the hammer inside the apartment. That's the Melissa Perez that officers encountered that night, right?
Yes, sir.
Okay, thank you. And before I move on, just like the rest of us in this room, the judge, the prosecutors, the defense attorneys, law enforcement in particular, when you encounter people out in the world, it is usually when something terrible has happened, right?
Usually we're not encountering people on their best day.
Right. No one's calling 911 when good things are going on, right?
No.
Right. Would you agree with me that on the whole, the failure to get Melissa restrained quickly to protect herself from hurting someone else or even herself was a failure, big picture, in this case?
Are you asking my opinion or?
Let me ask it this way, maybe morally speaking. I'm not asking you to say whether one particular officer or not did something wrong, but the failure to get Melissa Perez into custody quickly and safely so she could be taken to the hospital or to the jail was a failure in this particular case.
Again, you're asking me to kind of give a Monday morning quarterback answer.
And that's the nature of what we're doing here.
Yeah, and the only thing I can say about it is based upon the information that I was aware of at the time and the plan that we had come up with, that we were, beforehand, we were hoping that that was the hopeful outcome.
Getting her into custody safely.
Yes, sir.
Thank you for that. So kind of step back. You talked about your experience on South Patrol. We've learned now you've had a storied career in law enforcement. We thank you for that. I want to just show the jury, if I could, through you, give them a sense of what the South Patrol area looks like. Are you good with that?
Yes, sir.
Let me show you defendants' exhibits. Starting at 64, Tom?
64.
64, 65, 66, and 67. You can just take a look at these and see if they accurately portray some areas that have been discussed in this trial.
Yes, sir. As far as I'm aware, they're pretty accurate.
Thank you, sir. So at this time, defense would offer defendant's exhibits. We'll go this in this order. 64. It's got the number 61 on it, right?
It's 61 section, yes, sir.
So this depicts the 61 section of South Patrol?
Yes, sir.
Okay. And then defendant's exhibit 65. It's got the number 62 on it. Same thing, depicts 62 section?
Yes, sir.
Okay. And then defendant's exhibit 66. It's got the 63 on it?
Yes, sir.
Okay. And then defendant's exhibit 67. It says south on it, right?
Yes, sir.
Okay. And then in 66, there's an address. Is that the same address you all responded to in this particular case?
Yes, sir.
All right. Defense would offer defense exhibit 64 through 67. I'll send it to the state for inspection. No, I think so.
No objections to defenses 64, 65, 66, and 67.
All right, those are admitted.
May I call this one, Your Honor?
Yes.
Okay, Officer Chernak, we'll start with 67 first, kind of biggest picture here. We've got a map in this exhibit. Can you just explain to the jury what this map is depicting?
It's depicting the South Patrol service area.
And we've heard some testimony about the service area like south is divided into different sections, right?
It's divided into 3 sections.
And those are numbered.
61, 62, and 63.
All right, so starting with defendant's exhibit 64. What area is this on this particular map?
This is the 61 section.
Okay. And then defendant's exhibit 65.
And that's going to be the 62 section.
Okay. And you know where I'm going with this. Defendant's exhibit 66
It's
is
63.
and 63. Each of these sections, they have a sergeant assigned to them, right?
Yes, sir.
And so when something happens in a particular section, whoever the sergeant happens to be on that shift, it's their responsibility.
Yes, sir.
Okay. And so 63, assuming in here, you testified that this marker here, 6200 Old Pearsall Road, that's the address you all responded to that night.
Yes, sir.
squarely within Sergeant Flores' section that night.
Yes, sir.
Okay. And so when Sergeant Flores makes a scene, it's not as though he shows up and desires to take control as a sergeant. He has to take control because it is his section, right?
He has the ultimate authority over it.
Right. Because if it had been in 62, the sergeant for 62 section would have had ultimate authority, say, for 61, right?
Yes, sir.
Okay. We've seen video for you from that night. I think it's clear to the jury that you got there a little later than a lot of other officers. We had, what, more than 10 officers on scene there?
I can't tell you how many were actually assigned. I know we had a lot.
At least it showed that.
Yes.
And the video appeared to show you trying to find a way to get in that apartment and get Melissa Perez into custody, right?
Yes, sir. We were trying to come up with a plan.
And you'll have to excuse me for asking, but had you succeeded in getting in, you would not have been committing a criminal trespass, would you?
We had a legal right to be entering in.
Right? You have the exigency of someone who'd run from police and attack police, and you were going to go in and get her in custody, right?
Yes, sir.
All right. And it seems obvious from the video, but it seemed that your plan contemplated kind of getting the jump on Miss Perez in that apartment, right?
That was hopefully the idea.
Ideally, get in before she realizes you're inside so you can go hands-on or taser
or whatever you could, that was the minimum amount of force that would be effective to get her into custody, right?
Correct.
All right. Now, let's suppose when you got in, she got to you before that taser could be effective, and she had that hammer and was about to use it on you. You'd have to probably transition to lethal, wouldn't you?
Again, you're asking me to speculate.
Sure.
I don't, to be perfectly honest, I don't know if we would have had time to transition.
Okay. And if you didn't have time to transition and she had that hammer, it's possible, if not likely, she could have done some serious damage to either you or whoever she encountered first with that hammer.
I mean, the possibility's always there.
Right? And if you had had time to draw and had used lethal, do you understand that the state's theory in this case would say that you would be charged with murder in that circumstance?
Objection. Misstatement, Your Honor, since never said it in relevance.
I think that theory is pretty clear in the record, Your Honor.
You can rephrase your question.
Officer Chernak, had you gotten into the apartment through that back window with the desire to get hands-on with Melissa Perez or have the taser, but couldn't get hands-on, or the taser would have been ineffective because she's so close, that you'd gotten that gun out, would you have been justified in shooting her if she's coming at you with a big claw hammer?
Like,
Again, Your Honor, I'm qualified as expert.
Are you asking him as an expert?
Just based on his 30 years of experience, just based on his 30 years of experience as an officer and his impression of the events transpiring that night, I think the state's made it clear that their theory in this case is that the officers being in that apartment was unlawful, and they've made the case now that their presence may or may not justify their actions. I'm only asking this witness what he would do in that circumstance, not asking him to comment on anybody else's actions.
Okay, so you can ask him that.
So Officer Chernak, if you were in that situation, what would you do with big claw hammer being used against you?
that's kind of hard to answer because there's so many different variables that could be involved in that. You know, where are we? Are we in the bed? Are we in a open room where there's nothing? You know, where there's no obstacles? Is there a bunk bed? Are we in the hallway? Are we, you know, is there anybody else nearby that I have to worry about? So that question is really kind of hard to answer without, you know, I've learned in my experience that I can't say this is what I would do. Because again, like I said, there's so many variables in there. As I said, you know, I can't say yes or no what they were doing. Try this again. Sorry, my mouth's a little dry. I can't say, you know, sit here and say that what Sergeant Flores and Officer Elazar and Villalobos did was wrong. I can't say it's right because I didn't see it and I wasn't seeing what they were seeing. I wasn't there in real time. So for me to, you know, say that this is what should have been done, you know, this is I can't say that.
I appreciate your humility in that answer. And I guess ask the question more pointedly. In that situation, for you, in a situation where someone is attacking you with a hammer, would you agree at least that you would not let that person attack you with a hammer?
No, I would not.
And you would do everything that you could to stop that kind of force being used on you.
I would do what was necessary.
Thank you. And I'm glad you mentioned all the variables that could arise in a situation. Those are split-second decisions that officers have to make in the moment, right?
Yes, sir.
Now, watching the various videos we've seen, would you agree with me that the consensus among all those many officers there on scene is, you testified, we need to get into that apartment, we need to get her into custody?
That's usually how it's, what we usually try to do is quick, fast, you know, we don't want to be in a prolonged encounter.
In fact, acting with intention and quickly, that can prevent a situation from needlessly escalating, right?
Yes, sir.
And then it's important to maintain that control.
Yes.
And I think because you've been very clear with this jury and with us about what you did and didn't know, at the time, you didn't know about the bedridden old man in that middle bedroom, right?
No, sir, I was not aware of him.
And even not knowing about him, you were still on board with the plan of getting into that apartment and taking her into custody.
Based upon the assault on Officer Salinas gave us grounds to go in. So, you know, like I said, we had a legal right to go in.
Yes, sir. And I agree with you. We all do. There's been some discussion of tools that might have been available to officers on the scene. You actually had a shield in your vehicle that night, right?
Yes, sir. I was assigned to carry the shield for the 61 section.
Because each section, there's somebody assigned the shield, and this particular night was actually Down Young that had it.
Yes, sir.
As part of helping with the plan and participating in the plan to go inside, you didn't suggest to go get your shield out of your vehicle.
To be honest with you, I hadn't even thought about it.
And really, based on this apartment you're dealing with and trying to get into, the shield probably wasn't a very useful tool in that regard, right?
Trying to go with the plan that we had. Trying to get through the window with the shield and everything would have been a little cumbersome.
Right. So I want to turn to Alfred, Mr. Flores, that night. You were actually his FTO 17 years ago?
Many years ago, yes, sir.
So you trained Alfred when he came to policing from his first career as a zookeeper.
Yes, sir. He was a probationary.
Yeah. And so his demeanor that night, having known Alfred, you'd agree that he seemed calm, given the circumstances.
Yeah, he seemed like it didn't seem he wasn't running around like a chicken with his head cut off.
He
No,
wasn't amped up, right?
didn't seem to be.
Pretty conscientious.
He seemed to always be like he always was.
And how would you describe him? You say how he always is. How is he always? What do you mean by that?
In the couple years that I've been there as his, you know, with him being a sergeant, he's been to a couple of my calls. I've never heard him get, you know, angry or yell or seem to yell or get angry. So he's always, you know, somewhat calm and cool.
Right, because that night he wasn't screaming nasty things at Melissa Perez, right?
No,
He wasn't getting her amped up or taunting her in any way, right?
not that I saw.
And that would be against your prior experience with
I'm sorry?
That would be contrary to your prior experience with Alfred, right?
Yes, sir.
So I'm gonna show you quickly just a short clip from what's been admitted as State's Exhibit 3. This is going to be Officer Villalobos' body camera video. 1:57 a.m. And so I stopped the video here at 1:58:05. Did you hear in the video Officer Villalobos describing to Sergeant Flores that Melissa Perez has put down the hammer?
Yes, sir. I did hear
And
that.
so in terms of the ability to go in and get her safely, that has improved the situation, right? That she no longer has that weapon in her hand.
At that particular point, yes.
Right, because if something changes and that weapon's back in her hand, that complicates the confrontation, right?
It has the possibility to change how things get.
Understood.
I'm just saying I can get her from opening the door.
And we knew that it's something because she.
I am not there.
Okay.
Yeah.
So I'm asking you to come out and.
I'll do a routine, I'll do a normal walk.
Okay. Well, I didn't say you were wrong. I just said. So would you like to come out and talk to us? Hey, you're gonna make us go. Okay. Well, like I said, one way or another, what's gonna happen is gonna happen, okay? I'm trying to explain the law to you so that this doesn't escalate.
So before this has to get complicated, can you please just come out so we don't have to use force or anything like that?
No,
Why not?
because I already know what's gonna happen.
So it's gonna happen regardless.
What's gonna happen?
What's gonna happen? Tell us what is gonna happen.
Like previously I've been arrested
Uh-huh.
on false accusations.
Okay.
I'm not having it anymore.
This isn't false, you threw something and hit him with the opposite.
Accusations because you came and tore my door down.
Okay. Okay.
We're trying to be very patient with you and very
If you want to be
cordial.
conventional,
Uh-huh.
you respect that elderly man that I picked up in the street,
Uh-huh.
and you respect my property, and you respect my apartment.
We are trying to. If you would just come out, then your apartment, it. We tried to do this very peacefully.
You need a warrant.
No, we don't.
You ain't got no warrant.
I promise you I don't.
So if we had a warrant, you come out peacefully?
If you had a warrant,
You come
then
out.
they'll give you a warrant.
Okay, so hold on. Hypothetically, if we had a warrant, would
You need a warrant, don't act stupid.
So that's what I'm saying. What if we had one? Would you come outside?
You don't have a warrant.
Okay, but if we had one.
If we had.
If you had a warrant for what?
This
If
also
you
the
had a warrant for
warrant.
what?
So now,
Exactly. You don't even know for what.
does it
For
matter?
what? And a warrant for what? Explain to me just for what? You're the officer, right?
You seem to know
You
what
don't
it
know,
means.
right?
You seem to know what it means, so you tell me what the warrant is for.
No, you're the one who's harassing me, so you tell me what the
I
warrant is for.
just got here. I just
Yeah,
got
we're
here.
good. Look, hey, we're just trying to help you.
You're not helping me because you're harassing me.
How are we harassing you?
Because you're shining the lights, kicking my door down.
Are you sure that was me?
That was the other gentleman that kicked my door down.
Is your door kicked down right now, though?
They kicked it down. They turned off pictures and they turned off for free.
If it was kicked down, we'd be inside. Doesn't that make sense?
No, that's stupid. You don't have to remember rules.
What's wrong?
That's ridiculous. You don't remember rules.
I'm asking you what's wrong.
Now, there's cameras rolling, son.
What's wrong?
There's cameras rolling.
Where? Tell me where they're at.
Especially for the officer who took down my door.
Well, tell me where they're at so we can make sure we get that as evidence.
I got plenty of evidence.
Exactly, and now we like to see that because if we're in the wrong, hey, so if we have all this evidence,
You ain't got no warrant.
Stop the video here at 2:02:14. Officer Chernak, I'm going to show you Defense Exhibits 68, 69, 70, and 71. We looked at these on Friday. Are those fair and accurate still shots from that video we just watched here?
Yeah, these are stills from the video.
And who do they depict?
Sergeant Flores.
All right. At this time, defense moves to admit exhibits. Thank you, sir. 68, 69, 70, and 71. I'll tender to the state for inspection.
No objection to defenses 68 through 71.
All right, they're admitted?
May I publish, Your Honor?
Yes.
So showing you first Defense Exhibit 68. What's the timestamp at the top of this picture here?
2:02:11.
And so in the video, this is right before Sergeant Flores begins shooting, right? Does that look right?
It could be. I'm not sure exactly what time.
Sure. And then the next picture may help you here. Defense Exhibit 69. You ever seen Sergeant Flores' face look like that?
I can't say I have.
Same question for Defense Exhibit 70. Ever seen his face look like that before?
Mm,
And just for the record, Defense 70 is at 2:02:13, so just within a couple seconds of the first still I showed you, right?
mhm.
And then lastly, Defense Exhibit 71 at 2:02:13, still within 2 seconds. Ever seen Alfred Flores' face look like that before?
No, sir.
pretty genuine expression of fear. Do you agree?
I would guess, yeah.
Thank you, Officer Turnak. I have nothing further. I'll pass the witness.
Would you, is it,
My apologies to the jury, Judge.
Yes.
Thank you.
Yes, sir. Members of the jury, since the defense has just passed, it would be appropriate to go ahead and take a lunch break at this time. Let's give it about an hour and 5 minutes. It's 12:42, so let's make it 1:45. All right, we'll see you in about an hour.
All right, for the jury?